Welcome from the Authors Guild and Authors Guild Foundation. We're here for must-know copyright basics for authors. I have a feeling we'll actually go beyond the basics, full disclosure, but it'll all be information that you should know, I promise. Thank you for your questions submitted in advance. We'll be addressing a lot of those throughout the presentation. Many of you are wondering the same things, of course. If your question is highly specific, we might not have time to dive too deep into it simply because we have a large crowd here, but you're always welcome to email us, submit a legal help request if you're a professional member of the Authors Guild. And all guild members have the community forum where you can crowdsource advice from each other. But we're in good hands today on copyright info. We've got Kevin Ammer, Chief Legal Officer at the Authors Guild. He previously served in senior roles at the U.S. Patent and Trademark Office and at the U.S. Copyright Office. Kyle Maxey, staff attorney at the Guild for a few years now, and our CEO, Mary Rasenberger, who practiced law for over 25 years before taking the helm here at the Authors Guild in 2014. With that, we'll be looking for your questions in the Q&A box. We might type answers to those, so check back, and you might have gotten a written response in there from one of the lawyers here. And with that, I'll go ahead and turn it over to Mary. Thank you.
Hi, everyone. Thank you for joining today. This is a really important webinar, so I'm glad that we're seeing so many people on it. Just copyright is such an essential part of your career. We are going to go through a PowerPoint, which is quite long, so we will be going through it pretty quickly, and we will make the PowerPoint available. We can make it available on our website, and Johnny will send it out to everyone who registered as well. So let me screen share now. So I'm going to start with the very beginning, and that is the basis for copyright. So I think most of you know, or you should know, that copyright is actually in the U.S. Constitution. It is in the actual Constitution as opposed to the Bill of Rights. It is, I believe, the only right in the original Constitution. Free speech and those kind of rights are in the Bill of Rights, which was the First Amendment. But and why did our founders put copyright in the Constitution? Because they understood just how important having professional authorship was to a democracy, to their experiment in having the people rule themselves was their understanding of democracy. You needed people to be educated, and that means that you needed there to be writers, American writers. At the time, almost all books, I should say, were imported from England. So they wanted to create an economy for books, and maps were in the original copyright too, in this country. So it's just good to remember like how important copyright is to book publishing, to authorship, to the economy of publishing on which all of you rely. One of the first things to know is that copyright does not cover, it covers expression, original expression, in tangible medium. So intangible can be online, it can be, something that's readable by a computer, but it's got to be expression, which when you're thinking about books and written works is the actual language, or it's the way that it could be the narrative structure. It's anything that's creative in the work itself. It does not cover ideas. And this is something that I know when I was in private practice was people would often come and say, I've got this great idea and I want to copyright it, and be like, no, you can't copyright ideas. And to the extent your book contains ideas, anybody can use those. Okay. Also facts. Anybody can use the facts. And we're actually seeing this with some of the arguments that AI companies have about using books to train their AI without permission, or even to have outputs that contain facts from the books. They're saying, well, we're just taking information from the books, which actually is not true. They're actually using the books for the expression, for the literary expression that's in them, and the way that authors put words together. But it does mean that you can take facts from others' works without impunity, and also others can do that from you. And there is a practice that we've seen of, particularly in television, where, they'll call up the author and say, oh, we love this book. We want to do a TV show or series on this. And you work with them, and then they never sign an agreement with you. They never pay you anything. And they'll say, well, we were only taking the facts from your book. So I do not appreciate that practice, but just be aware of it. I'm sorry. So what is copyright? It's actually a bundle of right. The original right is the reproduction right, which is why it's called copyright. But there's also a distribution right, which is the right to distribute to the public copies of the work. And preparing derivative works means creating works that are based on your work. So that could be a movie, it could be a TV show, it could be a sequel. In the AI context, it could be a chatbot that interacts with your work, or any kind of new version of your work that somebody uses AI to create. Those are the main rights for writers. There's also public performance and public display for visual works and other works, and public performance for um, things like, music that is performed. When a motion picture is played, that's considered a performance, those kind of things. So just know that for publishing, the rights that you are granting are the reproduction and distribution rights to publish the book in various formats. And any derivative works are going to be licenses that will generally fall under subsidiary rights. You should not be granting many derivative work rights, for instance, for film or television, but generally speaking, publishers are going to want the right to create summaries, anthologies, that sort of thing, which are technically derivative works. Um, Let me see. Yeah. So how do you secure copyright? Well, under the 1976 Act, Copyright Act, which is the US copyright law that is still in effect, it's been amended many times, but it's still, the act itself is the 1976 Act. That created a new rule where all you need to do to have copyright in your work, whether or not it's published, is create it. So you have a copyright in your work from the moment of creation. The exception is a work made for hire, and I'll talk about that in a minute. There is no need to register your work with the Copyright Office to have a copyright, but you cannot effectively enforce it without a copyright, and Kevin's going to talk about that in a minute. Registration in this country, and only in this country, is very important to actually protect your copyrights. Um, Sometimes people say, well, I only have a draft. Is that copyrightable? Absolutely. It's already a work. And to the extent you keep working on it, I'd consider it the same work, but if it is substantially revised after publication, then you probably have a derivative work, depending on how many changes were made. And that is a new copyrightable work, which can be registered separately. So works made for hire. These are works where the copyright vests initially not in the writer, for instance, or the other creator, but in the person who employed you to write it. It pertains to any works that are written by an employee within the scope of their employment. Okay, so I'm looking at Kevin. If Kevin writes a memo as part of his job, or a brief as part of his job working for the the Authors Guild owns that, the copyright in it, not Kevin, and is considered the author. Now, you and I'm taking some time on this term because people use it rather loosely. for works that are commissioned or created under contracts. Um, if somebody hires you to write something, let's say it's to ghostwrite a book, and they say, or this is true sometimes for textbooks, it might say it's a work made for hire, okay? Or they might refer to it as that. A work, unless created by an employee, a work is a work made for hire only if it's commissioned with a written contract, and that written contract has to say it is a work made for hire. And in addition, the work has to fall within one of the 9 categories that are listed in the statute. Um, in terms of books and other text materials, the only categories that apply are educational texts. So yes, textbooks can be works made for hire. Also things like uh, tests and other ancillary supplementary materials for educational materials, educational texts, but also contributions to collective works. So that means, for instance, a story that's part of an anthology. Technically, that could be a work made for hire, but it's got to be commissioned by a written contract that says it's a work made for hire. So, if somebody just asked you to write a work and it doesn't fall within one of these categories, it's not a work made for hire. Okay, you should be aware of that, and the copyright vests in you, the writer. So, as I said, copyright creates an ecosystem that allows you to become a professional writer. It allows you to know that there is an economy out there that you can rely on to, if your book is good enough, to sell the book or to be hired to write. And in the contracts, you grant rights to the publisher or the platform or the distributor. And that's how, obviously, that's how you make money. I should say copyright also gives you the ability to control and limit how the grantee uses your work. So, trade book contracts, generally speaking, they will license the rights to the specific rights to the publisher for the term of copyright. And those rights are the exclusive rights to reproduce and distribute, as I said, for purposes of publishing a book. And uh, often, if you look at your contract, it says that in a kind of long-winded way. That's a summary of what most trade book contract grants are. But they are exclusive grants, and that means you, as the author, no longer have the right to reproduce or publish the manuscript for those purposes. And you know the right to give it to anybody else, of course. I mean, that's understood. But the there are also, as I mentioned before, there could be subsidiary rights, and those, if you have an agent, they will negotiate them very carefully, and you should too. Those are the rights that the publisher has to license out uses of your work. But it is a limited grant. And just to mention AI again, for instance, after looking through a lot of trade agreements, we are not seeing in the subsidiary rights clauses the ability to license out your work for AI training. And we don't think it's covered by the publication grant. But there are other things like output uses where the outputs contain summaries or quotations from your work. That is granted under the subsidiary rights clause. Now, there are reversion clauses in trade book contracts, and I'll talk about that in a minute. You need to make sure you've got one, and it's one that can be exercised reasonably. Academic presses we want to mention because often they do look like trade book contracts, particularly if the book is headed to the commercial trade marketplace. But sometimes some academic publishers do ask for a transfer of all copyrights so that they own the entire copyright. If you've ever had a contract, or particularly a university press contract reviewed by our legal team, you will know that we do not like those clauses, and we tell you to go back and get that changed to an exclusive grant. There's no reason that a publisher of text should acquire all rights, including all kinds of derivative uses to your work. So do push back on that if you see a total assignment of rights. The beauty of self-publishing is you get to keep your rights. You own them. You don't grant them exclusively to anyone. You'll give non-exclusive licenses to printers and ebook retailers. I think the one exception is, when you're in Kindle Unlimited and you agree to exclusively distribute through KU, um, and get the benefits that come with that, which is terminable on 90 days at any time. So I just would say for online platforms, just be careful to read the terms of use. What rights are you giving the platform? Really, really important to understand that. And freelance journalism also push back if they're asking for all rights to own the copyright in your work going forward. And I know like the New York Times and some other major publishers do ask for that, but and you're not going to get anywhere arguing with the New York Times on that because we've tried. But most other publications make sure, excuse me, that you're only giving them an exclusive grant for a specified period of time to publish. That is worth trying to argue about because you might want to reuse that work later on, retool it, rewrite it. That is your intellectual property. So rights reversion. As I said, this should be in any trade agreement and also academic press agreements that if your book goes out of print, and it will usually say if it goes out of print either 2 or 3 years after initial publication, then you can get your rights back. But you can't, you have to usually do something to get the rights back. You usually have to send a notice to the publisher and say, I want my rights back. The book's been out of print. And the publisher usually has a period, like 6 months, to republish the work. And if they don't, then the rights revert to you. Sometimes it will say the publisher will send you back a notice saying, actually giving you the rights, and you should try to get something from the publisher confirming that they are reverting the rights to you because one, you need that often for Amazon or to re-grant your rights. They often want evidence that you have your rights back. But two, it also means that the publisher is actually paying attention and recording the fact that they have reverted rights to you. Um, Out of print has many different definitions. It used to just be that there was no longer, they weren't keeping stock or printing. Now in the age of POD and ebooks, we recommend, and most of the big publishers have adopted a clause that says, excuse me, that it's out of print when sales or royalties to you fall below a certain level, often around $250 a year over two royalty terms. So on that, I just say that on rights reversion, we're going to have a whole seminar on that on December 4th. So stay tuned for that. And also we'll talk about termination which is another way to get your rights back in that webinar. I do want to mention, I see we've got a bullet here, and this is important to mention that if you have a work on the Anthropic Works list, um, and you've gotten the rights back, there is a box you need to check to show that you are the sole rights owner. It's like on the online form, it's on the bottom right corner of one of the pages. Make sure you check that because it is quite possible that the publishers don't have good records and they'll just go in and see that they're the publisher of the book and they might try to claim 50%. You are entitled to 100% of that fee from the Anthropic settlement if you've got your rights reverted. I guess, Kevin, am I still doing this? I think so. I'll hand it over to you in a couple minutes. Just real quickly, the term for copyright is life plus 70 years. That means the copyright expires 70 years after you die. This is under the 1976 Act. Before 76, it was a term of 28 years, and if you renewed, you would get an additional term, and by the date of the effective date of the 76 Act was 1978, January 1, 1978. by that time, the second term was, well, now it's 67. I think it was, what was it? It was, I actually don't remember, but you got 20 less, 47, 28 plus 47, I think it was. Um, Now it's 67 because there was the Copyright Term Extension Act, which actually took the terms from life of the author. It used to be plus 50 years. Now it's 70 years, and it tacked on 20 years to other terms. You should know that works made for hire and pseudonymous and anonymous works actually have different terms. And that is 95 years from publication. Or if it's sooner, it could be 120 years from creation, but generally speaking, just keep in mind it's 90 years from publication. And that, depending on how old you are, that might be a factor to keep in mind. If you're young, you might prefer, life plus 70. And I say keep that in mind in terms of deciding whether or not to publish something anonymously. So termination, I do want to mention this. So we talked about rights reversion under the contract. Section 203 of the copyright also gives you the right to terminate, but not until 35 to 40 years after the book is first published. And just for purposes of this webinar, we won't go into it in detail. There's a lot of like caveats to that 35 to 40 years from a date of first publication. But for most of you, that is the time to be thinking about. You do have to provide notice to the grantee. That means the publisher. And that notice has to be between 10 and 2 years before the date of the date of termination that you choose. So if you choose January 1, 2026 at the date of termination, it means that you must have within, and that's within the window of 35 to 40 years because your book was published 35 years ago. You need to have given notice before by December 31st, 2024. And the earliest you could have done that was January 1, 2016. I know, don't spend too much time noodling over that. Just know that those terms are there. This is just this chart shows the overlap, the termination period versus the notice period. Just be aware that the dates are there, or that the notice dates are important. They need to be followed. Also know that you have to record termination in the Copyright Office before the effective date of termination, and that there are other rules you have to comply with, and that failure to follow them will result in your not recapturing rights. So if you are at in that 35 to 40 year window, or it's coming up, I strongly recommend that you file a request for legal help from the Authors Guild, which, as Johnny said, is for professional members of the Authors Guild. If you're not a member, $149 a year to join, really easy to join on our website, and we will help you with your termination notice and walk you through all the details so it is done correctly and it is in fact effective, because there are a lot of ways to get screwed over and not have an effective termination. So you just want to make sure you do it right. Okay, I'm turning it over to Kevin now, who's going to talk about registration and then get into fair use.
Great. Thanks, Mary. Hi, everyone. So as Mary mentioned, this is a point of confusion, I think, for a lot of people, whether you have to register in order to protect your copyright. So just to sort of reiterate, your work is protected. You have a copyright once your work is fixed. So once you've created the work, you've written it down. If someone infringes it, that's unlawful. You are protected unless an exception applies. However, for what are U.S. works, so essentially if you are a U.S. resident or if the work was first published in the United States, you have to register with the Copyright Office before you can bring a lawsuit. And so that's, as a practical matter, it's essential to register to be able to enforce your copyright. Um, in addition, registration makes you eligible for some really important additional remedies if you do file a lawsuit. Um, and those are statutory damages and attorney's fees. And particularly attorney's fees tend, as a practical matter, to be really important for a lot of creators because otherwise, if an attorney is working on contingency, they might be reluctant to take the case unless they can be assured that they're going to be able to get attorney's fees. You gotta love those lawyers. So that's one reason why it's very important to register in a timely way. Now, the general rule, and what about timing? And this has been sort of an issue that we've seen come up with the Anthropic settlement. The general rule is that in order to get statutory damages or attorney's fees, in general, the work has to be registered before the infringement happens, right? There is an exception to that, however, where if you register within 3 months after the work is first published, you're still eligible. So, and that's basically, to sort of address situations where, if a book is published and it's infringed right away after publication, it's pirated immediately. We still, the law provides a way for the copyright owner to still get those additional remedies. And the basic idea, behind registration is that it creates a public record. The idea is that people are able to go to the Copyright Office website, look to see if a work has been registered, and if it has, who the registering party is. It is intended to sort of facilitate licensing, so they can get in touch with you and ask permission. We've had a lot of questions about when you should register, and what stage in the writing process it makes sense to register. The basic rule is whatever version you want to protect should be registered, right? So if you have an early edition of your book, a draft, for example, and you register it at that time, that will protect the work as it exists when you registered it. But then if you add more material later, the registration would not cover that additional material. So you would want to, if you wanted to protect that material too, you would have to register it then. There are the one sort of caveat to that is that you can register the same manuscript as an unpublished work and then register it again after it's been published. There's a distinction on the Copyright Office between published works and unpublished works, and they can be registered separately. So there's no real hard and fast rule, unfortunately, for when you should register. The important thing is to just keep in mind, each registration covers only the material that is part of the deposit that you send to the Copyright Office with that version. So this is, and again, we saw this in Anthropic. We're really urging authors to make sure that their contracts have a requirement that the publisher register their work within 3 months of publication. We unfortunately have heard about some situations where that wasn't done, even though there was a requirement in the author's contract with the publisher that the publisher was supposed to register. In some cases, that didn't happen, and so they were left out of the Anthropic settlement, which is really unfortunate. Again, here's another plug for our legal services team. If you're a member of the Guild, we can help you with contract negotiation, and we also have a model contract, book contract on our website, which we are updating to really provide strict language about this, because we don't want to have the situation happen again where somebody is left out of a remedy because their publisher failed to register in time. I think we can probably go to the next slide. Okay. So how do you register? Well, the short answer is you go to the copyright. You can do it online. You go to the Copyright Office website, and there are some good resources there. Or you can call them now that I guess they're back open. There are good resources to walk you through the registration process. Essentially, there are different types of applications depending on what type of work you're registering. I think we can go to maybe the next slide to highlight this. The sort of most straightforward option is known as the single application. It's $45. This is what you would use if you're registering a single work by one author, where you as the author are the copyright owner. It's the most sort of straightforward way of registering. The current fee for that is $45. There also are various group registration options. So for example, there is a group option for contributions published in periodicals. So you can register up to a year's worth of periodical articles under one group registration for $85. There also is an option for things like blogs. That's the GRTX is the sort of abbreviation the Copyright Office uses, short online literary work. So you can register between 2 and 50 short works between 50 and 7,500 words with one group application. One important thing to keep in mind, and again, sorry to sort of bog down with timing rules. The Supreme Court said a few years ago that in order to actually bring your infringement suit, the Copyright Office has to have basically made a decision, yes or no, on your registration application. So the time when your registration is pending, and with the shutdown, there were a lot of applications pending, no doubt. You can't sue during that time. You can, once the Copyright Office makes a decision, you can sue for stuff that happened during that period. But it potentially, can create some problems when people have to wait. Now there is an expedited option. It's called, yeah.
Kevin, we got a question in the Q&A that says they can't hear you very well. Could you speak up just a little bit?
Oh, yeah. Sorry.
Thank you. Sorry for interrupting.
That's okay. I'll try to speak up. I'm using these little earbuds, so apologies for that. There is an expedited registration option. It's not cheap. It's $800. But if you are, in anticipation of litigation, you're about to bring a lawsuit, you can consider that option if it's really important to get your work registered promptly. I'm sure we'll have some more questions about registration, but just to keep things moving, it's also important as an author to keep in mind getting permission if you need to. And we're gonna talk about fair use, and unfortunately, the rules are not always precise. But the best sort of safest route, if you're using quotes, if you're using photos, is to get permission, is to locate the copyright owner and to get a license or to get permission. Obviously, if the work is in the public domain, it's free to use. We're going to talk about fair use. So there may be, depending on what you're using it for, how much you're using. If it's just, a short portion, you may be able to argue that it's fair use. You should also think about Creative Commons license. A lot of works that you'll see online these days will have a little CC logo, which indicates that the copyright owner, is essentially okay with people making use of the works under certain conditions. Usually, it just requires attribution. So that's a way to sort of streamline the permissions process. in certain cases. What about the public domain? So this again, and not to sort of bog you down in legal minutia, but the current law, the copyright term depends on the life of the author, right? So the current, if you write a book now, you're the copyright owner. Individually, the term is life of the author plus 70 years. So you have to know when the author died, basically, to know if something is in the public domain for more recent work. For older works under the old law, it had to do with when the work was published. And the way the laws all sort of shake out now is that if a work was published in the United States before 1930, it's in the public domain. And every, year, January 1st this year, that's going to go, that's going to be extended 1 year to publish before 1931. I think I don't know if The Great Gatsby is already in the public domain or is about to be, but I
Yeah.
read, I
I
think
think
that,
it comes in on January 1st.
yeah. So I mean,
Yeah.
it's it's pretty interesting. Now that we're getting into the 30s, I think a lot of really well-known works are going to be entering the public domain. Bear in mind that those are the copyright rules in the United States. Unfortunately, there are different copyright laws around the world. And so it's important to, if you're publishing something overseas, it's important to know what the law is in that country.
So I'm just going to interrupt for a second, Kevin, to note the time. So I think we should move on to fair use because we got a lot of questions around fair use, but we're going to have to go riveting through it. So
Okay.
you'll lay out the 4 factors, and then I can just quickly go over some of the cases so that people get a sense of what, of how fair use is applied.
Yep. Okay, so fair use is an exception to copyright. So you have Mary talked about the exclusive rights. You as the copyright owner have the exclusive right to do certain things, reproduce the work, distribute copies, etc., unless an exception applies. And sort of the largest, and most talked about exception is fair use. Fortunately or unfortunately, fair use is decided on a case-by-case basis, and so it's really hard to predict in advance most of the time whether something is going to be fair use. The basic idea, is that, the law can't really account for every sort of use that might be permissible, and so the law leaves the fair use exception is intended to leave breathing room for things like research. If you write a review of a book, you're going to need to copy the book. It doesn't quote the book, rather. It doesn't make sense to require a license for that. Things that sort of we want to encourage without a license is why fair use exists. So there are 4 factors that courts look to and sort of weigh in the particular case. First is the purpose and character of the use, nature of the copyrighted works, so the amount of substantiality, and the effect on the potential market. I know Mary, you'll talk more about this when we get into the cases. When we talk about the purpose and character, one really important consideration is the use commercial or not, right? So the law generally gives more flexibility for things like nonprofit research, non-commercial activities. Whereas if you're doing it for profit, that tends to weigh against fair use, although it's not determinative. The other wrinkle under the first factor is this idea of transformative use, which is a hotly debated, very confusing issue in the law. But the basic idea is that if you are using the work for a different purpose than it was written for, if you're using it to illustrate historical facts, for example, or you're not using it for its content itself, the court will consider that to be a transformative use, and that is more likely to be considered fair use overall. We can go to the next one. Oh yeah. So then the Supreme, yeah. The second factor is the nature of the copyrighted work. This tends not to be very important. Basically, highly creative sort of, imaginative works tend to be protected more than sort of um, work, more sort of scientific or fact-based works, but that factor is not usually very important. We can go to the next slide. The third factor is the amount that you used. And importantly, you have to look at both the quantitative amount and the qualitative importance, right? So if someone takes sort of the heart of your book, or sort of the part that is really considered important, that's going to weigh against fair use. And there's a famous Supreme Court case involving the memoir of Gerald Ford, and a news publication basically scooped the book, before it came out, and they excerpted the part about the Nixon pardon, which was, really the only part that anybody cared about, let's be honest. Um, uh, and the court said, the Supreme Court said that it was not fair use, because even though they took a very quantitatively insubstantial piece, it was essentially the heart of the book, and so that weighed against fair use. And then finally, the fourth factor, this has historically been treated as the most important factor, is how does this affect your market, or potential markets? If the use serves as a substitute in the market, or harms its value, or not only the market for the work itself, but potential licensing markets for derivatives and so forth. So, you can imagine if you have a book, and someone, just to take a really simple example, if someone makes a movie out of your book, that obviously is going to impact the potential market that you have to license your book for movies, right? So that would be, almost certainly a factor against fair use. Mary, I'm going to turn it over to you to let you talk about the cases, but as I said, sort of fortunately and unfortunately, fair use is a case-by-case determination. It's almost never straightforward. It really depends on the facts of the particular case. And so once again, we really urge you to reach out. If you're a member of the Guild, we urge you to reach out to our legal services staff to help with these questions.
Yeah, thanks, Kevin. So I'm just gonna go through these cases really fast, but no, this is in the PowerPoint. So this transformative use doctrine started really with this Campbell v. Acuff Rose case going back to '94. Just so you're aware of it, this was a parody that Two Live Crew did of the Roy Orbison song "Oh Pretty Woman," and the court said, well, in this case, it was under the first factor, you have to look at whether, does the allegedly infringing work, does it, as Kevin said, does it merely supersede, in which case that's not likely fair use, but does it add something new with a further purpose or different character? And this is altering the first message with new expression, meaning, or message. This language has been taken apart by so many different cases, and it has led, I will say, to a very great expansion of the fair use doctrine. In that, in a sense, almost any use can be deemed to fall, any secondary use other than a pirated exact copy can somehow be said to be transformative. Okay, so then in 2023, the Supreme Court takes this case, Warhol v. Goldsmith, which is a photographer. Goldsmith had taken this picture on the left of Prince and licensed it to Vanity Fair, I believe it was, and they then had Warhol, and correct me if I'm wrong on any of the facts, created these images, or maybe he'd already done them, but they licensed this image from Warhol, but they also paid Goldsmith, the photographer. Okay, that was for the original use. Then more recently, They were having an anniversary, or I think it was maybe it was a big
It was when
article, even an
Prince
issue
died.
on Prince. Sorry?
It was when Prince died.
When Prince died, thank you. Yeah. And they took one of the other silkscreen images that Warhol had created at the time and used that, and they did not go back to, they got permission from the Warhol estate, they did not go back to Goldsmith, and she sued. And here the court took this case on, um, in part to look at this transformativeness doctrine. And the only takeaway for you guys here is that it did say this was not fair use, that it was a use that should have been licensed. But they took this opportunity to kind of correct some of the expansion of this transformative use doctrine. Um, and they said transformative use is not an on-off switch. Um, and it doesn't automatically, if a use is transformative, all the other factors don't necessarily fall into place. It's that the transformative use has to be weighed against commerciality, even just under the first factor, and that you also have to consider the justification. So this was the court's way of really trying to get their hands around the transformative use doctrine and limit it, where we had seen a whole line of cases where the courts had said transformative use, all of the other factors fall into place, can't be substitutive because um, it's not because it's transformative, so it's not a substitution. And then it would say the second factor doesn't matter. The third factor, well, if you have to use the whole thing for the transformation, it's okay. And under the fourth factor, if it's not substitutive, then it can't be harming the market. So that was like just the analysis that you saw in decision after decision before this Warhol decision. So I'm going to go back in time to some other cases just to show you how courts have dealt with fair use in some of the literary cases. So, and this will give you a sense of, how much is too much, hopefully. So, and this was a case where a writer, Ian Hamilton, wanted to do a biography of Salinger. Salinger refused. So Hamilton found all these unpublished letters and decided to make a book of them, and did it without permission. And the court said this was not fair use because the letters were the backbone of the biography. In other words, the Ian Hamilton had just taken too much. He was really capitalizing on the interest in Salinger instead of providing a critical study. Then, just a few years later, we see this case. There was a biography of Richard Wright where the author quoted, Margaret Walker quoted from just a handful of letters and 10 unpublished journal entries. And the court said only 1% of all his letters were copied, and it was done in context. It was informational. It was fair use. I love this case because I remember aging myself, but when it was litigated, it's really interesting. So, most people of a certain age know Gone with the Wind. I know when I've taught this case in the past and was always surprised that a lot of young people are not familiar with it. But it was a very famous movie when I was a young person. And a saga in the post-Civil War in the South. And Alice Randall did a kind of a sequel spin-off, I guess you would say, of it, um, which was written from. So Gone with the Wind it's a third-person saga that focuses on this heroine Scarlett O'Hara and her love interest. And when done gone, it tells the kind of the same story, but from the perspective of one of Scarlett's slaves, who is in fact her half sister, same father. And the court said, actually, this is a fair use. This is the kind of use that should be fair use, that even though it takes characters, it didn't take too much. It is a different story, and it is a parody of the original in the sense that it's critiquing the original, and the racism in the original book. So, but then we see in Salinger v. Coltine, Here, Colting wrote a kind of a sequel, again, a spin-off of Catcher in the Rye, using the main character, Holden from Catcher in the Rye, but he's 60 years older now. And the court said, actually, this is not fair use. He took too much. He didn't really, he wasn't critiquing the original. This is the kind of use that should have been licensed. Here's a lexicon that somebody did of all the Harry Potter books. Court said, well, it's slightly transformative, but took way too much of the actual work, and not enough commentary. And Rowling herself said, that this was, there have been a lot of books that had original insights on the world of Harry Potter, but this wasn't one. It just took too much. And she did allow the same author to publish a new version with more commentary. Here, there was a use of a photograph of a, not a, it was a poster originally, and the image was in a book about the Grateful Dead. And the court said, even though they took the whole thing, and this was normally a kind of a licensed use, so this decision actually really was very upsetting to a lot of copyright owners. They said, yeah, using the whole thing was okay because it was done for a different purpose in the context of telling the story of the Grateful Dead, and the original purpose was to advertise the concert. Here, these are a whole series of books where there's done by the same guy, Colting, is in the Salinger case, not the Salinger case, where it took classic books and made children's versions of them. And the court said, not fair use, not enough commentary. This is a licensed kind of use. I think I'm going to skip over all that. I think we've done enough on fair use. The takeaways are, don't use more than you need for the purpose. Comment, as long as you're using a quotation or other material in context, commenting on it should be okay, but take as little as you need and don't take the heart. I think we'll skip over some of these since we are almost out of time. And I just want to say, when your rights are infringed, contact the Authors Guild. We can help you send a takedown notice or cease and desist. And I'm going to turn it over to Kevin to real quick talk about copyright and AI. And then I think if it's okay, we'll go over a little bit to answer some of the questions. And sorry to take so much of your time, but hopefully you've learned something. Kevin?
Great. Yeah. So AI obviously is a huge topic right now, that we're thinking a lot about. So the basic rule is sort of an old rule. I mean, there are lots of court cases predating AI, that establish pretty conclusively that the term author in the copyright law means a human, right? So there've actually been these funny cases where someone has tried to register, a work that was supposedly, written by a spiritual being. There was a funny case from a few years ago about a monkey that took a really kind of funny selfie. And the court said, no, author means human being. There's no copyright for any non-human works. So that principle applies to AI, right? So, and recently the Copyright Office issued guidance kind of reaffirming that idea. And they've said, we're not going to register works that have been solely generated by AI. And there actually has been a court case about that too, but that seems pretty well established. Where it gets complicated, as you can imagine, is when someone uses AI as a tool, where they, might put in multiple prompts into ChatGPT to sort of shape the output in the way that they like, or maybe they select outputs and they arrange them in a way that is original. The Copyright Office has said they will register any human authored aspects in situations like that. And as I understand it, what you have to do is on the application, you have to indicate what part of the work was AI generated. And so you disclaim that. You say, I'm not claiming the AI generated material, but I am claiming the selection arrangement or the modifications that I did. I mean, when you think about it, it's similar to tools that, technological tools that creators use all the time, right? And there are a lot of hard questions, um, you can think of music, if someone, creates sounds using guitar pedals or computer effects, to what extent does their creation, where does their creation begin and the use of the tool begin? These are difficult questions, I think, that courts are struggling with. Like I said, the Copyright Office has issued some guidance on its website about these principles, what you need to do to apply to register something that was AI assisted. Um, as I mentioned, you have to provide a statement in the author created field, sort of describing what it is that you created and what you're excluding. Also keep in mind that if there is something called a supplementary registration, which essentially allows people to correct errors in previous applications that were granted. And so that's an option too, if you registered something that was AI generated and you want to make a correction to that.
Great, thank you, Kevin. And I just add that, one rule of thumb is if text is AI generated and you don't revise it and make it your own, that's what needs to be excluded from the registration. It's really easy to do. You just check a box and say, some text is AI generated. But if it's just a de minimis amount, you don't need to um, exclude that. And if you use AI just to help you brainstorm, organize your thoughts, research, that is not something that you need to disclaim. That doesn't impact your copyright. Um, so it's just if you used it to create the expressive content, which could be like having it outline your entire work, the entire novel or whatever that, but that's where, as Kevin said, it gets a little tricky. I'm really sorry that we've gone over. I see we still have a lot of people on the line. So let's turn to questions and we'll go for like 15 minutes and you need to leave, just drop off. Okay. Is that okay, Johnny? I'm assuming so. Okay. Kyle, do you want to start asking questions?
Yeah, yeah.
Okay.
We got a lot of them here. So the one, Mary, you would want to talk about was mandatory deposit. Do authors still send in hard copies to the Copyright Office?
Yes, and that is a definite yes under mandatory deposit. And Kevin was at the Copyright Office more recently than me, so he may have other advice. But there are best edition requirements for mandatory deposit. So when you register, you can send in your mandatory deposit copies. That is what one usually recommends. That's what the Copyright Office wants, and that is 2 copies of the best edition, which will be, if you have a hard copy version, they want the hard copy. You have a version with better acid-free paper, they want that. It's listed on there. If your best edition, if you don't have a print copy, then you can submit an ebook edition. If you only have paperback, they want that. They want the paperback.
Okay. Another question was, how does the uh, display right of copyright, how does that interact with book banning that's occurring in the libraries right now? I thought that was a very good question, very relevant.
How does it interact with book banning, the display right? I'm not sure I understand it. So maybe if you understand it, you should ask it. You should answer it. I mean, sorry.
Well, I guess I just meant, I guess the question was just meant like, you know, I guess with books being banned in libraries, does that violate the display right of copyright at all? I mean, does that implicate that at all in any sort of way? I mean, is there anything, I don't know. I just thought it was an interesting question because I hadn't thought
Yeah.
of it.
It is an interesting, yeah, it does. And I mean, not displaying a work is not violating copyright. It's just if you display it publicly without permission, it would be. But showing a copy of a book in a public library would not infringe the public display right,
Okay,
just
good
to
to
be
know.
clear. Yeah.
This next question, we got a lot of questions about, and again, I'm sorry if you guys had answered this during the presentation. I was busy doing the Q&A. A lot of questions about, copyright after death, right? So can your rights be inherited? What does that look like? Do they automatically inherit your copyrights, your beneficiaries? Does that have to be transferred via a will or other sorts of things? So.
Yeah, so that's a really good question. And we do at least one webinar a year on literary estates and handling copyrights after your death. And I am sure that we've got several of them actually on our website that you can review. So there is a lot of considerations there, but generally speaking, if you say you can do whatever you want with your copyright in your will, okay? Not true for the termination right, but we'll talk about that when we do a webinar on termination rights. The termination rights flow under the statute. But for the ownership of the copyright, it goes under your will. If your will mentions nothing about your books, which actually is more common than you'd think, um, it goes under the residual rights clause. And almost any will is going to have a residual rights clause. It says all other property. Um, also, um, if you die without a will, then it just goes through intestate succession to your heirs. It's just considered another piece of your property. We do advise that you really think about your literary properties and how they will be cared for after your death. And that means not just who is going to own them, but who's going to administer them. And a lot of people, I should say, if you've got a big literary estate, a lot of people put them in a trust or a corporation of some sort.
Next question. If you receive your rights back from your publisher, do you need to re-register copyright for each work, or how do you go about changing the I guess the ownership of the copyright?
Yeah, Kevin, do you want to take that?
Yeah, it's a really good question. You don't need to re-register the work. Once the work is registered, whether you did it or the publisher did the registration, that counts for purposes of, I mean, the work is still registered even if the ownership later changes hands. Now, there's another process in the Copyright Office called recordation, which basically means it's similar to recording a deed or something like that. But basically, you have the option of recording documents with the Copyright Office to that documents showing a transfer of rights, and that helps with sort of record keeping, and you get some legal benefits if you do that as well. But that's a separate process from registration. You don't have to re-register your copyright.
Next one is, what should I do if I discover my publisher did not submit my book to the Copyright Office and it is not registered with the Copyright Office?
Yeah, so I saw there are a bunch of questions about registration. So, and Kevin talked about this. So, if your work has not been registered yet, register it is the first thing I do. As Kevin mentioned, going forward, make sure not only that it's in your contracts that they have to register within 3 months. We probably are going to have a new model clause that makes that 2 months, and then if they fail to register within that 2 months, then the author can do it, but the publisher has to reimburse them for it. And there might be a penalty. I mean, and the reason is that it's so important, as Kevin said, that you lose certain rights if you don't register within that 3 month period. So going forward, make sure, do whatever you do it yourself. As Kevin explained, it's really easy to do yourself. It's not expensive. We had a webinar with Rights Click. A few weeks ago where they can do it for you for not a lot of extra money. Also, Bowker, where you buy your ISBNs from, they also have a service where they will register for you. There are many, many ways to register. Go ahead and do it. It does mean if you do it now and the book's already published and it's already been infringed, unfortunately means that you do not get statutory damages or attorney's fees, but it will protect you against in the future, if your works infringe in the future, you will get those statutory damages. So remember, it's within registration to get the statutory damages and attorney's fees has to be registered within 3 months of publication or before the infringement. Does that answer the question?
I think so, yeah. That's it. And I guess kind of a similar kind of piggyback off of that is, when, if ever, is it too late to officially file with the Copyright Office?
Never. You can always register your work if it hasn't been registered before.
I thought that was.
Yeah.
My next question, you kind of touched on this, Mary, in your section about out of print, but basically, someone was asking, what if your contract basically doesn't have a definition of out of print, and their work's essentially just in print on demand? Is there anything that you can do to kind of get out of that? Is there anything, is there an industry standard kind of definition that's kind of, I guess, broadly used across the industry? What does that kind of look like?
I would say if they're not selling your book anymore, really, I would send a notice of intent to get your rights back. But this may seem like a cop out, but this is actually what I would tell anyone. It's like it depends on exactly what your contract says. So use our legal services and they will walk you through it. And we do advise people all the time on getting rights back and can help you do this.
I can attest, as someone who we do that a lot. So yeah. Um, we had a couple questions about AI, and I think you already had gone over this, but someone had just asked this in the chat, and I thought it was a very good question. Is using apps like Grammarly to check spelling, grammar, etc., considered AI generated?
No. Using spell check?
Yeah, using spell check and other apps like Grammarly to check your spelling.
No. We consider that de minimis use. The Copyright Office does too. You don't have to disclaim that.
Great. Let me look.
And we do have our certificate of human authored, and we actually spell that out. For human authored, we want the work to be, substantially human authored. If you use AI as a tool, if you use Grammarly and other tools like that, that doesn't affect whether it's human authored.
This is another interesting question too. Are audiobooks with AI voices in foreign language translations made with generative AI copyrightable?
That's such a good question. So the narration is not copyrightable because it's AI generated. But the underlying work is copyrightable. So that means that, nobody, if you use AI to do a narration of your book, nobody can copy that audiobook without infringing the rights in your book, which is the underlying work. So you are protected against piracy of the AI narrated audiobook.
Great. I'm trying to see if there's any other questions that you all didn't already answer.
Oh, I see one about registering blog articles. Kevin did mention, I know we went over it really quickly, but there is a way to register short works up to 50 that are published within a certain amount of time. And is it 6 months? I forget, or a year, I think, a year, something like that. But you can publish them as a group for $85. So you don't have to publish every single blog. Is that right, Kevin?
Yeah, that's right.
Yeah, so you can register them. Yeah. And again, yeah, it's person said to put a copyright mark in a year. That is a way to notify the public or any potential user that you're claiming copyright. And that is important, but you still need to register for the statutory damages and attorney's fees, and to bring a lawsuit at all. Okay, yeah.
This is another just quick
Mhm.
question. Obviously, with the government being shut down for as long as it was, this is wait times are going to be kind of longer. Is there like a standard wait time to hear back from the Copyright Office? This question was just asking. They hadn't heard back from them in a while. What should they do essentially?
Yeah, so well, obviously the office has been closed for how long now? I mean, at
It's
least a
close to
month.
40 days at this point.
Yeah, wow. So they're going to have some catch-up time. I think in recent, years, it's been just a couple months to get a registration through if done online. But remember, your application is not complete until your deposit copy has been submitted. And we did find with the Anthropic suit where there were a lot of works where it turned out the publisher hadn't registered them. In some cases, they filed the application but just never sent in the deposit copies. And so it's good to remember that your application and your registration date go to complete application filed, which includes the application itself, the fee, and the deposit copy. So I am assuming though, to answer the question, I mean, Kevin, I don't know if you have any thoughts, but there's gonna be a lag time right now to get caught up.
Yeah, they publish their uh, pendency times, you know, on the website. I don't have it in front of me right now, but I mean, that's, it's something that you can imagine they're really concerned about. But yeah, it's usually a period of months on average. Unless there's a problem, a lot of times they will correspond with the applicant to get, the Copyright Office will have to reach out to the applicant to get more information, and or there's something wrong with the deposit or something, so that can add time. But um, it's usually a few months is my guess if it's just sort of a straightforward application.
Yeah, thanks. I'm going to answer one more question because it was on a slide and we didn't get to it about titles. Titles are not copyrightable. Short phrases are not copyrightable. Titles, single titles also cannot be protected by trademark. And that's why you see a lot of similar titles out there, right? What can be protected are series titles. Okay. You can get a copyright, not a copyright, a trademark registration or claim trademark rights without a registration in a series title. And there has been some litigation and some fighting around that. However, the series title has to be unique enough and not descriptive. Sometimes you'll see series titles, particularly in genre fiction, that are really descriptive of or use words that are very commonly used in that particular subgenre. And that is something that should not be trademarkable. Okay, I don't know. This is tons of really, really good questions, you guys. Thank you. I'm glad there's so much interest in this topic. Again, if you're a member, you can always submit a legal request for help, particularly like on things like fair use issues. We do have copyright experts on staff, and any assistance you need with registration, terminations, and getting your rights back. So with that, I think, also feel free to email us with further questions, and stay tuned for other webinars down the road.